Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I'm here every weekend at this time and on this station to bring you, the landowner, valuable information that you need regarding natural gas development in Pennsylvania. I'm excited because we're always looking to branch out, and we're starting the broadcast on another station in Tioga County this week. So kind of very excited about that, actually. So we're even going to be on Saturday and Sunday on that station. So I want to say thank you, everybody, to the new listeners, and hopefully we'll have a good show for you today. And I'm going to tell you, I'm actually very excited about it. Just back to my kind of introduction, who I am, and if you are a new listener, I'm Attorney Doug Clark, and I represent landowners and only landowners. I do not, have not, and will not represent oil and gas companies. I've been doing the radio show since August of 2010, so we're working on our 5th to 6th year of doing the weekly radio show, All Things Marcellus. The show is designed for you, the landowner, to get you the information you need. I try not to make the show, the regular show where I'm speaking, to be too commercial. Don't try to say, call me. You probably get enough of the commercials in the break. But there are times during the show that I think there's something that's important enough that I have to kind of break my own rule. Usually I'll say commercial alert or something to that effect to say, hey, look, I acknowledge this sounds maybe a little commercial, but it's an important thing. You'll hear me say often, whether you call me or somebody else, please call somebody, and I truly, truly mean it. So at the Clark Law Firm, what do? I represent landowners. I represent landowners for gas lease negotiations, gas lease amendment, extensions, modifications. Going to talk about that today, and I know it's going to be a good show. Pipeline agreements. You'll hear in the commercials, you hear me talk. I do a lot of shows, have done a lot of shows on pipelines, and because it's such a big thing out there. I've done pipeline agreements. I've negotiated, consulted pipeline agreements with over 50 different companies across Pennsylvania. So we're talking about there's a lot of work out there, a lot of things going on, and I give that information to just give you some perspective as to the experience that I bring to the table when we're talking about the radio show. Also, I do more and more. I'm doing estate planning, as many of my clients, prior clients, are transitioning or have transitioned into the royalty phase of their lease and realize that, hey, good estate plan is very important, and we need to get a plan for you as an individual. I do any and all contract reviews, consultations, and of course negotiation, any type of contract, roadway, pipeline, surface use, meter site, compressor station, you name it, anything related to natural gas development here in Pennsylvania, I can be reached at any time, 570-307-0702. That's 570-307-0702. And of course, royalty, unitization issues, and so on. So again, if you're new to the show, here's what we do. We do the show every week. And then what I do is tomorrow, Monday morning, this show will be posted up and be available on our websites. And if you haven't visited the websites, go check them out. Make it a point. pagasleaseattorney.com, pipelineattorney.com. Great landowner information. Whether you're looking for representation or looking for quality landowner information, go to pagasleaseattorney.com, pipelineattorney.com. Have today's show up and available. You can go listen to the show in its entirety. So if you can't make it on a Saturday or Sunday, you can go check it out at the website. We also have, I haven't looked recently at how many shows, but at least I think the past year of shows are available on the website, and we index them by topic. So if you want to go, you want to learn about gas leasing, you want to learn about pipelines, You want to learn about an interstate pipeline project. What do you do? Meter sites, compression sites, deductions, royalty issues. Go to pagasleaseattorney.com. You can read the materials there, but then also you can go back, listen to radio shows. Again, I've been doing the show since August of 2010, so really, really excited about that. So, okay, you are listening to All Things Marcellus with me, Attorney Doug Clark, Clark Law Firm, and here's what I want to talk about today. I'm very excited because last week I was talking about lease amendments, modifications, or ratifications. I had no idea, but very excited about this because I had a case, got a new client over the past week, and sure enough, what comes in, but kind of what I expected that I would start seeing more of, given the slowdown, and we talked a lot last week about natural gas prices, the impact on the ground, the impact that it's having for companies, the impact that it's having for landowners. We're not seeing wells being drilled as quickly. We're not seeing the pipeline projects move as aggressively as we would if the price of gas was higher. So what does that mean? Well, most leases are going to have a term that something has to occur within a designated time frame, or that lease would expire. So what happens is when companies aren't actively drilling and they're not out there because the price of gas is too low and they want to make profit, obviously they're going to spend $5 to $7 million to drill a well. Well, they want to get some return for that. And if the gas is only being sold at $1 to $2 and sometimes even less per MCF or per unit of gas, well, doesn't make sense to go out, commit a lot of money to drilling when you're going to have a hard time recouping that money because the price of gas is so low due to the abundant supply. So by not drilling, you're going to cut the supply, hopefully, as a company's perspective, increase the demand, drive the price up. Then you can always find your balance, then increase the supply to meet that equilibrium that would be ideal. Very simple. That's a very, very simple example. There's a lot more at stake, a lot more factors involved. But the idea being that with the low gas prices, you're not seeing the aggressive drilling. Well, what does that mean for a landowner? Well, you can have leases that are coming on the time frame where they're about to expire, and the company's not drilling, so they're not able to meet the requirement of the lease to, say, either drill, obtain a permit, be working towards drilling and production. So if they don't do that within a designated time frame of the lease, that lease is going to expire. Example, we have a 5-year gas lease. Company has to do something, which is generally conducting some sort of operations, which is usually defined in the lease, but operations isn't what you may think of common sense-wise. Doesn't mean that they have to be drilling, you're getting royalties. It could be simply filing for a permit. So the point is, you have a company, you enter into a lease with the landowner. You have a 5-year lease. That 5-year lease may have a company option to extend the 5-year lease if the company pays you, the landowner, the same bonus money or bonus consideration that they paid you the first time. So here's the example I want to talk about today. And as I often do, I'm going to change the facts a little bit, not to be too exact for a specific client, but the whole gist of this explanation, evaluation is going to not be changed, and it'll be very clear. Now, another thing that I say is, you may say, well, this doesn't apply to me. There's so many other things. I try to design these shows that they're not limited to a specific issue that's only going to apply to a specific group of people. We want to also have issues that, they directly may affect a smaller group of people, but through this explanation, you're going to hear some lease terms in the original oil and gas lease that you want to avoid. And then also you're going to hear how companies design these leases and design amendments and modifications to operate and benefit the company, obviously, and not you, the landowner. You're listening to All Things Marcellus with me, Attorney Doug Clark. I am here every weekend at this time on these stations. Join us, and also check out pagasleaseattorney.com, where I have radio shows archived for I think about the past year, and have been doing the show for the last 5+ years. Okay, here we go. Have a consultation with a client this week, and here's the background. Client sends me, they have what's called, I want to get this right here, they have what's called an amendment of their oil and gas lease agreement. So it's called an amendment. It's a document provided to the landowner saying, hey, we would like to amend or change the terms of your gas lease. Very common. If you go back, you look at PA Gas Lease Attorney, done many shows on this because it's a real hot subject. But it continues to be a hot subject, and it's becoming more of a hot subject because due to the lack of drilling, you're seeing leases that are going to expire because the company is not meeting their burden to conduct operations or apply for permits, whatever it may be, in order to hold the lease. So if they don't do anything, the lease is going to expire. So, okay, landowner calls, says, hey, I got this amendment of oil and gas lease agreement. Interested in doing a review and consultation. Great, ideal, exactly what I would recommend. So they send to me the amendment of the oil and gas lease agreement. They send to me the original oil and gas lease. We do some digging. We find that there was a declaration of pooling and unitization in this case. Also, went online, we're able to find that there has been some activity in this production unit that includes a portion of this landowner's property. So that's very interesting to us. You got to understand what to look for, where to find it, and then you have to find it. So that was very important. So we do some background digging. So we find out, we also look at what's been permitted and what has been the activity in this area. So those now give us the basis of information that we need to review so we can talk, or I need to review, and I need to review with my client so we can discuss what this amendment is, what's the impact on the existing agreement, and look for any piece of information that can give us an idea of, hey, is this a good thing to do to amend this lease or a bad thing? And I'm going to tell you, in this particular case, I think it was probably a very bad thing, in my opinion, in this particular case. But there are other cases, and I've talked about this before, where an amendment to an oil and gas lease is something as a landowner, your initial thought is, boy, I don't like this. And many times you wouldn't like it. However, there are many times that when you're given an oil and gas lease, and this is where you need specific, detailed advice for your situation, some people are handed an amendment in oil and gas lease, and boy, they should definitely enter into it, in my opinion. Very, very clear. However, other times, person handed an amendment to their oil and gas lease, well, their first move should be to rip it up. The key is to understand, hey, what does this mean? What do I have? How is this going to change things? There's so many other factors to look at, and that's where you need specific advice. But you need to know that if you're given an amendment to oil and gas lease, there's a lot of things that you need to consider. And here it comes. I do this almost every week. If you are dealing with a company landman, you need to know, and you will be, he or she does not work for you. They work for the company. So you better not be relying on the landman, the employee for your, in this case, adversary, despite that they want to say partnership. At this point, it's an adversarial relationship where you're trying to do the best you can. They're trying to do the best they can. So they're not going to give you, in my opinion, the information that you need to make the best decision. That's where you need independent help. And that's not to say, hey, call a lawyer because you need to, hey, we want business. It's because a bad decision can cost tens of thousands, easily, in many cases, into the hundreds of thousands, and absolutely into the millions of dollars in cases. You have to understand these. We're going to talk about this specific amendment. I love this situation. It's a great example. I'll be right back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark, here every weekend at this time and on this station. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Going to jump right into this. So we're talking about lease amendment modification. Here we have a landowner who had entered into a gas lease in 2005. That gas lease had a 5-year term, so it went from December 2005 to December 2010. At the time of December 2010, the gas company had the option to extend the agreement by making a payment in the same amount as the original bonus. In this case, we'll say that this property is a 100-acre property and that the original bonus payment was $50 per acre. So in 2005, there really wasn't anything going on with Marcellus Shale. So at the time, the landowner entered into a very basic form lease. Form lease being the lease that the company landman comes out, provides to you and says, hey, we're going to give you $50 and we'd like you to sign this gas lease, 5-year lease, 5-year option, 12.5 royalty percent, which was the standard percent at the time. So all sounds good. Actually, in 2005, this landowner have been signing leases for a while and nothing ever happened. So now comes 2005, and it's actually at $50, and that was considerably more than they were offered in previous years. So they say, wow, okay. Landowner says this seems like a pretty good deal, goes ahead and enters into the gas lease. Well, come December 2010, landowner now sees where people are getting $5,000, $6,000 an acre in some areas, and as high as routinely 20% royalty, sometimes even 21%. So landowner says, boy, I hope my lease expires so I can get into this new leasing market. Well, companies, again, pretty smart guys, pretty smart company, guys and girls. So what do? Of course, comes December of 2010, they hadn't done anything. So they send a landowner another check, $50 an acre for the 100 acres that the person owns. And they've now bought themselves from December 2010, 5 more years of time to do something, to conduct operations, to hold the lease. So they give them $5,000, which is the $50 times 100 acres. So they give them $5,000 and they extend the lease for another 5 years. So it's set to expire now in December 2015. Okay, fast forward now. Here we go, December 2015. Well, the company comes to the landowner and sends the landman out, says, we'd like to amend your oil and gas lease. Well, landowner says, well, geez, my oil and gas lease was set to expire in December 2015. Let's see. Okay, give me the paperwork for the amendment. Well, I talked about this recently, and it's not, I only say this because it's just a reference point to show that this is the type of things that occur. One of the things that I've talked about was, watch companies who try to disguise what they're really asking. And in this case, I think this is an excellent example. The landowner was given an amendment. An amendment is a change in the terms, to amend it, to change the existing oil and gas lease. You'll see amendments for such things typically as, okay, the original oil and gas lease, we could only go to a 640-acre maximum unit size. So we'd like to make that a bigger unit. We'd like to be able to go up to 1,000, 1,200, whatever that number may be. So very common lease amendment would be, hey, landowner, we'd like to amend or change your lease to allow us to drill a bigger unit. Now, we have to look at those circumstances. Sometimes, again, it's a great deal for the landowner and you should do it. But many other times, not such a good deal. But when you really investigate everything, you may realize, hey, even though I don't like it, this may be a better option for me, because what you have to look at is, if you don't do it, is there a possibility maybe your lease will terminate? And if your lease terminates, maybe you have a lease at 20% royalty. Well, if it terminates, your new royalty rate that you might be able to negotiate in a new lease may only be 12.5%, 15%, 16%, whatever the case may be. You have to look at everything. You have to look at your lease. You have to look at the amendment. You have to look at what's going on around you. You have to look at what this company has done in the past, what other companies have done in the past, and make the right evaluation for you and your circumstance. There's no message board anywhere out there. There's no gas sites. There's no communication with people that's going to, over the internet, that I've ever seen. It's going to help you make a decision for your specific situation, not your neighbor's situation, not somebody else in a different county who's writing on the internet that you don't know. You need to understand what's right for you and your situation. I'm Attorney Doug Clark. You're listening to All Things Marcellus here every weekend on this station at this time. So make sure you tune in. And if you miss any of today's show, you can always go to pagasleaseattorney.com, pipelineattorney.com. Check out today's show. We'll have it up tomorrow. And then also many other shows that we have available and archived up on the website. So, okay. So this individual comes to me and says, hey, have this lease amendment. Here's my lease. Here's my amendment. Look at the amendment. And, you know, this is what I say. I was just kind of like, wow, shaking my head. In some ways, I guess, small little bit of pride. Well, it's a shame. But this particular amendment of the oil and gas lease, I would say, yeah, technically you can call this an amendment. But the reality is it's a lease extension. And what's even more troubling here is really what it is it's probably extending a lease that has already or is on the verge of expiring. So if you are, and this can happen, you can have a lease that say expired on January 1st, but you agree on January 10th. So even after the fact that lease would have expired, you could agree to go ahead and extend the existing lease, even after the expiration date. You can do that if it's written properly. But think about this. Well, when you do that, when you're extending an expired lease, really what you're doing is you're entering into a new lease. The new lease that you're entering into just happens to be identical in this case to the old lease, but the reality is you're unleased now, and the question is, are you going to amend this 2005 lease? Are you going to amend it to only add a couple more years onto the lease term? So let me back up and explain that. So you have a 5-year lease that you signed in December of 2005. December 2010, there was a 5-year option. Company exercises that option, doesn't do anything by December 2010. So what do? They pay the landowner the same bonus payment that was due under the initial lease to buy themselves 5 more years to December 2015. Now, here we are, December 2015. The company comes to the landowner and says, hey, yeah, your lease is expiring December 2015, but we would like to amend it. Again, how are you going to amend it? We're going to amend it by adding 2 years onto your lease. Think about that. What is that, an amendment or an extension? You're extending the lease. Instead of expiring in December 2015, it's now going to expire in December 2017. You could, properly, I would form this, or I would title this, extension of oil and gas lease. But you say it's an amendment, which, doesn't sound such a big deal at times. So this landowner, we talk about, hey, look, they're not really amending. The only thing they're amending is, instead of you having a 5-year lease with a 5-year company option, what they're doing is they're saying, yes, you agree, we'll amend it so it's a 5-year lease. Then we had a 5-year option, and you're going to amend now, so we'll have a total of 7 years. And in this case, they were offering literally hardly any money at all. I mean, a very, very small amount of money. Very, very small. So what are you really doing? What you're really doing in that scenario is you're entering into a new lease, because you're essentially now, as of December 2015, you're no longer under this old lease because the company didn't do what they needed to do to hold your property. So, are you willing? Now this gets really fun and interesting. Think about this. What you have here is, are you going to extend your 2005 lease, which is really what you're being asked to do? The amendment, as they ask it, the amendment is to agree to extend a 2005 lease for an additional 2 years for virtually no money. So this amendment is to say you have now, as it stands in December, we'll say you're now unleased because your old lease expired. They want to essentially kind of revive the old lease and carry it on for 2 more years. Well, what do we need to do? We sure as heck need to go back to that old lease and really look at it, to really dig it up, to really investigate it, to look at all these different terms and realize, hey, look, think about it. In 2005, what kind of leases were people signing? You know, the lawyers weren't negotiating. People weren't really negotiating very much. The price, my example here, $50 per acre, there wasn't a lot going on. So most people, and in this case as well, people were signing form leases, meaning the actual document, the lease that was brought out to the landowner in 2005 was signed at that time. It didn't have any protections. It had no addendum terms at all. It has the royalty rate at 12.5% with full deductions. You as a landowner, this what's called an amendment brought out to you in December, January 2015-16, brought to you as an amendment to your existing gas lease, is really asking to essentially extend this gas lease for 2 years, and it's going to be the same terms of your existing gas lease that you entered into in 2005. Most likely, there are better terms that are going to be available. Do you want to extend the form lease that you entered into in 2005 for virtually no money? I'll explain much more. Generally, that answer, and again, not specific advice, but you need to understand this and you need to make the right decision. And you need to understand that in a lot of cases, this may not be the thing that you want to do. I'm going to talk a lot more about that after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So I want to jump again right back into this. So we're talking about a landowner who was offered a lease amendment, or at least that's what the company calls it, is a lease amendment. But the reality is, in this example, the company is actually asking to requesting to extend or continue a lease that has expired or is literally about to expire, say, any day. In this case, though, it's probably already expired. So the company is saying, hey, here's an amendment. We want to add 2 years on to your lease. Now, if it's a good lease, we have to look at, again, you got to look at your scenario. You have to look at your situation. If, for example, you have a 20% lease for royalty, and we know that if you weren't under lease anymore, that the best you could probably do in your particular area where the property is located, we know that the market is about 15% royalty. So you may be very interested to keep your 20% royalty lease alive so it doesn't expire. Remember, though, companies aren't stupid, so if they know you have a 20-year or 20% royalty lease that's on the verge of expiring, what are they going to do? Well, and asked people in Tioga County which shale leases were expiring even a year or so into the future where landowners had a 15% royalty. Company comes and says, hey, we want to offer you a top lease or a new lease, and for only 12.5% royalty in a lot of these cases. Well, landowner says, well, geez, I already have a 15% royalty lease. Why would I do a new lease for less royalty percent? Well, company says, well, if you don't do it, we're just going to let your lease expire, and this is what we'll offer you in the future, if anything. So you got to look at that type of scenario too. So we have to really evaluate. You got to dig deep. That's a key part to this. Information, knowledge, understanding, key to make the right decision. So we have a situation then. If it's a good lease, we got to look at it and say, hey, maybe we don't want this thing to expire. But if it's a bad lease and say the market in the area is higher, say your lease was 12.5% and people are signing at 15% today, well, you're probably better off letting that old lease expire and doing a new lease. But we really got to look into this specifically. This is not specific advice for anyone. These are general concepts to get you thinking, to make sure that you understand that these are issues we need to be thinking about, we need to be studying, and we need to be analyzing to make the right decision for you. And again, there are many more aspects to this than what I'm able to cover on any given radio show. So, all right, this scenario isn't a scenario where the landowner has a 20% royalty. Remember, the original lease was signed in 2005. That lease was signed on a form that is a very bad lease form for the landowner. The form leases, the lease that a company representative, the landman, comes up and presents to you, says, hey, I want to do an oil and gas lease. Here's our lease. We'd like you to sign it. That lease is drafted by company lawyers based upon decades and a century plus of experience in oil and gas leases. They know how to write these leases to maximize the benefit for the company. So in 2005, when nobody was negotiating anything, think about what that form lease would look like. Very company friendly in this case. So we go back, we look at the 2005 lease. So here's some things I want to point out. One of the things about this lease, and people who listen to the show know I talk so much about pipelines because I think it's so important that you limit in your lease pipeline authority that the company has, that what pipelines they could put in or not. We limit that because you want to be able to either say no to pipelines in the future or negotiate them. Very, very important. I've done pipeline agreements for hundreds and hundreds and hundreds of thousands of dollars, and if the landowner had not negotiated or inserted certain language in their gas lease, then we would have had virtually no leverage, and a couple $100,000 might have ended up being literally a couple $1,000, and I'll explain what I mean. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, okay, in this particular lease form that the person signed in 2005, remember, it first off, $50 an acre, 12.5% royalty. Remember, royalty, 12.5%, that's the lowest allowed by law in Pennsylvania. I'm going to talk about more royalty in a second. But earlier than that even, this lease gives the company the ability to install roads, electric power, telephone facilities, pipelines, appurtenant facilities, necessary or convenient for the use and transportation of products from the premises, meaning your property, and this is critical, and neighboring lands. Not adjacent lands, but neighboring lands. So it appears that you may be giving pipeline rights that the company can come and say, hey, we have this lease, we're going to install the pipeline, even though maybe you're not getting gas from that right now. Well, here it goes on from there. It goes on and states, and this gives you should give you more concern as a landowner, goes on to say, those rights that I just read, the roads, electric power, pipelines, and so on, those rights shall survive the term of this agreement. They shall survive the term of this agreement, meaning once your gas lease ends, the rights that I just read, pipelines, roadways, telephone facilities, and so on, those rights survive your gas lease even after the gas lease terminates. We don't like that on the landowner's side. So it says, those rights shall survive the term of the gas lease so long as operations are continued on the lease or adjacent lands. Now, we are getting some adjacent language there, but you can still be in this scenario where you have pipelines, roadways, and you're not getting any benefit, and your lease is actually terminated. We want to avoid that. Now, I'm going to stick with this pipelines here for a second. And this is kind of, this is crazy here too. I've talked about, I've had pipelines for literally hundreds and hundreds of thousands of dollars. Many cases I've done where the person was paid. But again, you got to look at your leverage, a lot of things to look at, but $100 or more a foot, a lot of things involved there. But I don't want to get too bogged down on that. But I do want to say that another section in this original 2005 lease states that notwithstanding the above, meaning despite other things in the lease, the company shall still have the right to continue to use any pipeline rights of way herein granted upon a single payment to the landowner of $2 per rod. Okay, what in the world does that mean? Well, what that means is that they continue to have these rights for $2 per rod, which is a combined total of 12 cents per foot of pipeline. 12 cents per foot. 12 cents. Again, we've done pipelines for hundreds of dollars a foot. It's not the standard, but 12 cents per foot. That's crazy. But in 2005, that wasn't crazy. Do you as a landowner want to extend these lease terms? Or would you rather say, hey, I'd rather my lease terminate and look to enter into a new lease? Or since my lease has terminated, essentially I'm a free agent. This is a new negotiation, and I sure as heck ain't going to agree to that. So those are two examples. Let's talk about royalty. And I'm going to tell you, I'll never have enough time in this show to go through all the different problems of a 2005 lease that we would like to improve upon. But I want to talk about royalty here for a minute. Royalty here is 12.5% state minimum. Commonwealth of Pennsylvania minimum royalty, 12.5%. Also, the royalty language, there's the percentage, but really important that most people, and I think a lot of, probably even most lawyers, don't understand is you have to go deeper. It's not just what is your percent, 12.5, 15, 18, 17, 20. It is what is the royalty calculation language. So if my royalty is 15%, but I can have full deductions and the gas company can sell to an affiliate and give me that rate, I'd much rather have 12.5% without deductions and stronger royalty language. So you can't get stuck on royalty percentage alone. Critical factor without a doubt, but cannot be focused on solely. We got to look at the royalty calculation language. And in this case, in 2005, as hopefully you can imagine, the 12.5% minimum allowed by the state. The calculation language, it's about as bad as there is available. It's terrible royalty calculation. So this language, what do I mean by that? Well, in this case, the company is allowed to take any and all deductions for these post-production costs. So those, as many people know, can be substantial. Maybe you can't eliminate that in a new agreement, but maybe you can. Boy, it's certainly worth the try. Also, then we look at the company we're dealing with here, and I can say to my client, hey, routinely in the past, I have been able to get the company to agree to language that's going to minimize deductions. That language alone, if you could get that in a new lease, even at 12.5%, is probably over the lifetime of this lease worth over $100,000. That alone. Now also, remember, this old 2005 lease, it's going to be extremely company friendly. It also says that they can sell, the company who produces the gas can sell to an affiliate of that company, which we always need to be careful of. And so they can sell it to an affiliate and give the landowner that price. Well, we got to watch, because there's some question. If you're able to sell it to your affiliate, maybe you sell it for less money, and so the affiliate can go out and sell it for a higher price. The landowner gets royalty on the low sale price of the main company to the affiliate. The affiliate, and I'll run this with math. Say that the producing company sells to their affiliate at $1. Also, they're allowed to take deductions for post-production costs, so that could even get reduced. That affiliate then goes on and sells the gas, say, for $3. Well, the landowner is only getting royalties on $1 because the royalty, and they're only getting 12.5%, because the lease says that you are entitled to what this company gets when they sell their gas, and they're allowed to sell it to an affiliate. We want to get out of that if we possibly can. So this royalty language in 2005, as we may expect, is about as bad as it gets, and it's 12.5 state minimum. So if you don't enter into this agreement, what's the worst thing that can happen? If you don't extend your lease, if you don't agree to what they call an amendment, what's the worst thing that can happen? Well, as far as royalties go, it can't get any worse. You're already at the state minimum, full deductions for every possible thing, and the kicker, they can sell it to their affiliate, and that's allowed as well. So you can't, in my opinion, pretty much can't do worse on royalty. So if you say, hey, I'm not interested in this amendment or extension, well, maybe you're not going to get a new lease right away, but as it goes forward, if there's gas there's a good assumption that you're going to have a future lease offer. Look at the size of the property, many other things to consider there, but really good chance. So that's got to be factored in. So if you're only given a small amount of money as a offer to extend your lease, and that lease is to be extended at the worst possible royalty percentage with every deduction, and the company can sell it to their own affiliate and pay you royalties on that price, and again, they're only giving you a little bit of money, very little bit of money to sign. Wow, you on the lose side, on the what do I have to lose side, not very much. And there's even more, and I'll talk about it here in a minute. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So we're talking about a lease, what's been called a lease amendment, but really it's a lease extension. Sometimes companies come with these prior to the expiration of your current and existing gas lease. Sometimes they come right after your gas lease may have actually terminated and say, hey, we want to extend your terminated lease for another couple years. Or maybe they're coming and there's another month or two, maybe there's 6 months left, and the company wants to extend for another, say, 2 years. Well, what we have to do, we need to look at the terms of the existing lease. We need to understand what we think or know the existing leasing market to be. Also, we need to discuss maybe the existing market is not really good right now, but let's look ahead in another year, 2, maybe even 3, and say, well, would I rather have this lease, which is a really, really bad landowner lease, extended, or would I rather wait and see how this thing develops? Well, that's a real individual question. But I'll tell you what, here's some things that help you in your evaluation of this type of scenario. Say that company wants to extend your existing lease for 2 years, and like in this case, they're not hard. They're hardly offering any money. I can't get too much into the money, but I'm just going to say, hardly anything. Really hardly anything. So you're talking about for a very, very small amount of money as far as a bonus to extend a terrible lease for 2 years. Well, maybe we would agree to no bonus if we were extending a lease which had a 18 or 20 or 21% royalty, because we know that today's market is probably about 15% royalty in this particular area. But when we have a lease that says it's from 2005, and what's interesting, think about this. Companies enter into leases that have a 5-year lease and a 5-year option. Extremely common, and especially 2005, 6, 7. Well, what do we have? Those were entered into at a very low price. Our example here, $50 an acre. So what happens is 2005 for 5 years in 2010, maybe you entered into it in 2006, so 5 years is 2011. Company didn't do anything. They know they can extend it for 5 more years very cheaply, in this case, only $50 an acre. So they extend it. So now the new expiration date is 2015 or possibly 2016. And so what we have is, even though your lease is expiring in 2015, 16, 17, really it was entered into 10 years ago because it's already been extended once. So leases entered into in 2005, 6, and 7, as a general rule, are not good leases for landowners. So if you're going to extend your lease, we need to have a reason why. And if the reason is, well, the company's offering me $100,000 or $200,000 to extend my lease, and that money would be very important to me right now, and I'd rather have that bird in the hand, and I understand I have a bad lease, but that's a lot of money, and if I don't extend it and that money goes away, if I don't ever get a lease in the future, I'm going to be awfully sick. I'd rather take the money and get less royalty in the future because at least I have a high degree of confidence that I'm going to get this money. That makes sense, but we got to look at it. You got to talk about all these things. However, if you're offered hardly any money and your royalty provision has the lowest allowed by state law and allows for every deduction under the sun and allows for the company to pay you royalties based upon the price they receive from an affiliated company, let's think about that. So you're hardly offered any bonus. They want you to extend essentially one of the worst leases going. You may be wanting to sit back and say, yeah, although there may not be a lease offer right now, in a couple years or a year or a couple years, I have a feeling that instead of $50 is what well, not even that, they're not even offered that. Instead of hardly any money, much less actually than $50 an acre. So instead of that, how about I'm in a position where this very small amount of money isn't going to be a big deal to me at all because it's virtually nothing, and I don't want to extend this worst lease, one of these worst leases going. I'm willing to sit back, and although you're not going to offer me a lease right now at better terms, I have a feeling that once the gas market rebounds, because I believe it will, I think that I probably can't do worse than this in the future. So if the worst thing that happens is you don't develop my property, well, you probably weren't going to develop it anyway. So the only thing I lost was a little bit of money you were offering up front. But say you have 100 acres. Well, if they're offering you $1,000 an acre in the future, which people in this area have been offered very recently, that's $100,000. So you're talking about say maybe a couple thousand versus 100,000. That's a real big windfall, and maybe that's a risk that you're willing to take. A very sensible risk in this particular case. Also, maybe in the future you get 100,000 and maybe you get 15% royalty and no deductions. Now your overall net gain on a 100-acre parcel is, right off the bat, you're at $100,000 and you're going to get no deduction. You're probably talking hundreds and hundreds of thousands more in the future. No deductions, 15% royalty. We can't predict the future. But what I can do is look at what you have and say, okay, what do we think is going to be the worst thing that can happen in the future? What do we think will be the best thing? And we talk about that, and we weigh your options and look at your individual circumstance. A wrong decision, a lack of information, trusting and relying on the gas company landman who works for the company, not you, the landowner, can cost you hundreds and hundreds of thousands of dollars. Hundreds and hundreds of thousands of dollars. And in this particular case, I know what my client is going to do. In this case, though, I think it was less than 2 hours from beginning to end, and we had a very lengthy phone call. So this person now feels a lot better about this situation, is very comfortable, and is making an informed decision, which I strongly believe is going to be a very good decision for them in the long run. So that's it. For an hour or two of time, they've learned everything about this scenario. They're looking at it in the way they should be looking at it. They're going to make an informed and a proper decision for their circumstances. Everybody needs to do that. You need to do it. Whether you call me or somebody else, you need to do this. Please do not rely on the company landman. There are thousands of stories out there, very negative ones, for people who did. Whether it's me or somebody else, please, 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 we don't want you to make the same mistakes. We don't want you to be taken advantage of. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and I want to finish with this. Look, we're talking about money aspect. Remember this 2005 lease, if you're negotiating a new lease, well, here's some of the terms that you'd like in a new lease that you don't have in the other one. There's no indemnification language, meaning that you're exposed for operations on your property. You can be sued. There's no language in there saying a company will defend you or indemnify or hold you harmless or pay any judgment that may result from their operations. So if they come out, they operate on your property, God forbid somebody gets hurt, whether a worker, a trespasser, who knows, somebody gets hurt, well, you can be sued. And maybe you didn't do anything wrong, but at bare minimum, you're going to have to defend it. Nobody wants to be sued. You need to have indemnification language. The 2005 lease doesn't have it, and they want you to extend it for virtually no money. Also, I talked about the royalty calculation language. We want to get more royalty, and we want to have a better calculation process that's going to work out better for you as a landowner. The 2005 lease, no addendum terms, no input on the potential location of a well, pipeline, or any activity. We want to have that. Nothing with any detail about restoring the property at all. Nothing about any type of fees if the company operates, a well site fee or anything like that. And certainly nothing to limit the pipelines. I read, we're talking about 12 cents a foot we were talking about earlier. You need pipeline language. It's going to limit what they can do. So in the future, you can either say no or negotiate a new pipeline agreement. Again, these are only small examples. But please, landowners, beware. I just want to finish again. I want to thank everyone because we got a whole new group of listeners today, and always really excited about that. You miss any of today's show, pagasleaseattorney.com, pipelineattorney.com. I'm going to be here every week at this time on this station. Have a great week, everyone.